So good evening, everybody, and thank you for coming to this Geneva Academy Wednesday meeting. The Geneva Academy Wednesday is a series of lectures and interactive lectures, I would say, organized by the Geneva Academy of International Humanitarian Law and Human Rights, and organized in particular by Patrick Labuda and Antonio Coco, who are teaching assistants there, but more than that, at the Geneva Academy. And they took this initiative last year, and since then, the Geneva Academy Wednesdays have been quite a success, because the purpose of these meetings is to invite speakers to give a presentation on a topical issue concerning international law, and then to have discussions, and then to have a discussion with the audience in an interactive way. Therefore, we will explore topical issues of our contemporary world. And today we have Professor Marko Milanović, who will address the question of the War on Terror, Part 2, International Law After Paris. And as you have seen from the invitation, he will explore this topic by focusing on three aspects: the interplay between international humanitarian law, human rights law, and terrorism, which is quite big stuff; the geographical and temporal scope of IHL, of international humanitarian law, and the law on the use of force against, in particular, following the strikes on Iraq and Syrian soil. So I guess that everybody knows Professor Marko Milanović, who is associate professor at the University of Nottingham, and since 2 years is visiting professor at the Geneva Academy of International Humanitarian Law and Human Rights, and is very well known also for animating the EGIL Talk blog, and we often read him on topical issues. So I guess that's exactly an EGIL Talk done in the context of the Geneva Academy Wednesday, a bit longer perhaps than
yes.
a post on the blog. So Marko, you have the floor. Thank you
so much, Paula. Thank you so much for inviting me. It is truly a pleasure to be here, and thank you all for coming. So yes, I mean, as you know, the new Star Wars movie is coming out today, so that's part 7. And I am talking about War on Terror, part 2 only, at least so far. But you can see it's a movie that has, you know, the potential for a number of sequels, maybe prequels, if George Lucas sort of gets a hold of them. And the sort of starting point of my talk is the idea that 9/11 was somehow a watershed moment in international law. So when 9/11 happened, we started talking about many, many important issues. We revisited some old topics, but some new topics also got a lot of urgency. Many new claims, many new legal claims were advanced by very important, powerful actors in the international system, especially the United States. In the 3 areas of law that Paula mentioned, I will talk about. So the jus ad bellum, the jus in bello, and human rights. So, you know, the whole idea that the United States was somehow engaged in a global armed conflict with terrorist groups, that it could detain or target people on the basis of some kind of status or membership in those groups, that it could depart from norms that are more amenable to peacetime, et cetera, et cetera. So you all know that type of discourse, you know, the stuff that we've talked about for the past 15 years. Now, when the United States made all of these claims, it also received a lot of pushback. So it received a lot of pushback from people teaching IHL in Geneva, but who cares, you know, really about what they say? No disrespect. It received pushback from states, some powerful states as well, especially from European states. And what is intriguing about the current moment we are living in is that it's especially those states that pushed back against some of the more extravagant claims that now may be in a position of crisis that could induce them to make or accept similar extravagant claims. And so if you think of the situation Europe finds itself in now, it's one where it's crisis across the board. I mean, pick a topic, Europe is in crisis. It's a crisis of the Union itself, it's a financial crisis still, a debt crisis still, a political crisis, will the UK stay, will the UK leave, all that stuff. It's the refugee crisis, which is itself caused by the Syria crisis, which is in many ways now directly affecting Europe. So it's no longer simply some place in the world where non-Europeans are, having fun killing each other. It's the fact that the civil war there is also directly affecting Europe through sending 1 million refugees in the past year, through spawning many nasty organizations that are doing terrorist attacks like the one in Paris, right? So it is this atmosphere of crisis that changes probably the outlook of many European governments, or at least pushes them in a certain direction. And you can see that in how the French political elite reacted to the Paris attacks. So what was the first thing that President Hollande said after the attacks? He said, "We are at war." Yeah? So he adopted immediately the rhetoric of war that you'll remember was the rhetoric, the main sort of rhetorical and later legal point that was propounded by the Bush administration after 9/11. He said we are at war. His prime minister said we are at war. The opposition in France agrees that they are at war. It's a very similar situation to the one in the United States today. When you look at how dysfunctional the American political system is, the Democrats and Republicans still agree on one thing, and that's that there's an armed conflict with Al-Qaeda. That's that terrorism is to be fought through law of armed conflict or armed conflict means, not simply through criminal law or human rights or whatever. There's a bipartisan consensus on many things when it comes to fighting terrorism in the United States, as you can see, in part through the continuity of many of the policies between the Bush administration and the Obama administration. So yes, the Obama administration stopped the whole enhanced interrogation program, but it was Obama who escalated, for example, the use of drones or targeted killings. Mm-hmm. So there's a lot of consensus in America. Similarly now, President Hollande adopted a strategy that many left-wing people in times of crisis adopt, which is to preempt the right wing by taking the right wing's policies from them and adopting them as their own. So you can see sort of the sour face of Nicolas Sarkozy when, when Hollande says we're at war, because that's exactly what Sarkozy would say, right? So now you have this type of bipartisan consensus in France, at least, as well. And when you have that type of consensus evolving, pushback becomes difficult. So even the ICRC, the sort of guardian of international humanitarian law, had to adjust some of its positions if it wants to engage in meaningful dialogue with the US government. Right? It cannot say we're denying, we're disputing that you're in a global armed conflict with Al-Qaeda, No, it cannot say that. Or at least it will say that pro forma, because it needs to engage in a dialogue with US officials. So, the political moment is conducive, therefore, to the consolidation of some of these extreme positions. So let me now move to the substantive issues. I will first talk about the jus ad bellum, so the law on the use of force. You know how since 9/11, the big topic in the jus ad bellum was self-defense against non-state actors. So there are many, many controversial questions in the jus ad bellum that have plagued us in various different crises over the years, but self-defense against non-state actors is the big thing. Now, what do I mean by that? I mean whether Article 51 of the Charter, when properly interpreted in light of subsequent practice, requires that an armed attack for the purpose of that provision, which triggers the inherent right to self-defense, requires the attack to be attributable to a state. That's the question. So if you read Article 51, it does not say if an armed attack occurs by one state against another state. Right? It only says if an armed attack occurs. So a number of governments since 9/11 have interpreted Article 51 as essentially allowing self-defense action even when the attack itself is not attributable to the territorial state the state on whose territory the force is being used under traditional rules of state responsibility. So for example, the United States could say we can attack Afghanistan and topple the Taliban regime there because Al-Qaeda operated from their territory, even if the attack, the 9/11 attack, was not directly attributable to the state of Afghanistan. Or today, the United Kingdom is saying, we can strike at ISIS in Syria, even if the conduct of ISIS is not attributable to the state of Syria. Right? So that's the whole question of self-defense against non-state actors. Now, as you know, there are many, this is one of the most discussed questions in international legal scholarship. Many different people adopt wildly diverging positions on this question. Some are holding sort of to the, dogma of the latter half of the 20th century, pointing to ICJ decisions like the Nicaragua case as establishing that attribution must exist for a right to self-defense to arise. Others are saying, no, we should apply more flexible, unwilling, or unable test that really forms part of the necessity analysis under the customary law that regulates self-defense, et cetera, et cetera, et cetera. So you know what the debates are like. Here comes Syria. And if you look at Syria, not only is it a mess in very real human terms, in political terms, legally it is just incredibly complex. You can just see the number of actors that are involved in the Syrian conflict. When it comes to the external actors, so all the states using force on the territory of Syria, they all have different legal justifications. So, for example, members of the US-led coalition, starting with the US, but also France, UK, whatever, they rely on the consent of Iraq when it comes to striking targets, ISIS targets on Iraqi territory, but they rely either on the collective self-defense of Iraq or on individual self-defense of their own, right, when it comes to attacking ISIS targets on Syrian territory. Russia, on the other hand, which as you know supports the Assad regime, is relying on the consent of the Assad regime to use force on Syrian territory and regards the use of force by coalition members as essentially being unlawful, as exceeding the scope of self-defense, and as violating the sovereignty of Syria. Many other questions arise. So, for example, there's this whole idea of prohibition of intervention in civil war and whether the Assad regime, for instance, is capable of granting valid consent to Russia. That's one issue that I will not really get into. There's an alternate theory of implicit consent by Syria. You know how Syria has frequently remained silent, depending on which state uses force. So it has not unequivocally condemned the use of force by every other state other than Russia on its own territory. So you could, for example, regard that as some kind of implicit consent by the Syrian government, et cetera, et cetera, et cetera. But the main claim, with regard to the Western states using force in Syria is self-defense, collective and individual. Now, as I said, positions in scholarship vary widely. My own view is that we are in a situation of indeterminacy. And we have been in a situation of indeterminacy at least since 9/11. What do I mean by indeterminacy? I mean that if you look at the question on formal grounds, so using formal sources of international law, the text of the Charter, the subsequent practice, the decisions of the ICJ, depending on what result you want to achieve, you can always make a formally valid argument that gets you to that result. So if you want to justify the unwilling and unable theory, you can do that. If you want to justify an attribution requirement, you can do that too. On formal grounds, there are few ways through which you can make, you can say clearly the law is X. The law is not clearly anything right now. But what we can observe since 9/11 is how states have strategically used this indeterminacy to suit their own ends. So, for example, the American administration, not just in the ad bellum arena, but in the in bello arena, purposefully confuses several different issues, like, for example, the global scope of the armed conflict, et cetera, in order to create ambiguity. Ambiguity is sort of the basic point. Or if you look at Israel acting against Hezbollah in Lebanon, in 2006, a claim that many states accepted as being a valid claim to self-defense, even if it was disproportionate, if you remember that particular conflict. Israel itself professed two different justifications for striking at Hezbollah in Lebanon. One was that Hezbollah was part of the Lebanese government, i.e., that the conduct of Hezbollah was attributable to the state of Lebanon. The other being that Article 51 essentially does not require attribution. And you can find statements from the spokesperson people to the Israeli government or from the Prime Minister Olmert at the time that are essentially contradictory. So states have relied on this ambiguity. And we are in a similar position with respect to Syria. And my favorite example of that ambiguity is the recent Security Council resolution 2249 that was adopted with regard to ISIS. Some of you may have seen it. Dapo Akande and I wrote a post on Eagle Talk that's called The Constructive Ambiguity of Resolution 2249, where our whole point is essentially how this resolution is crafted in a way that exploits this ambiguity to the maximum political benefit possible, right? So ambiguity is essentially a tool of policy, which is to bring states with very different interests and positions together, right? To bring them closer together without requiring them to renounce positions that they have adopted before. And the best way you can see this is to read the key paragraph in that resolution, which is operative paragraph 5. And let me do that right now. So in operative paragraph 5, the Council calls upon member states that have the capacity to do so to take all necessary measures in compliance with international law, in particular with the United Nations Charter, as well as international human rights, refugee and humanitarian law, on the territory under the control of ISIL, also known as Daesh, in Syria and Iraq, to redouble and coordinate their efforts to prevent and suppress terrorist acts. This is all one sentence, by the way, okay? Committed specifically by ISIL, also known as Daesh, as well as the Al-Nusra Front, and all other individuals, group undertakings, and entities associated with Al-Qaeda and other terrorist groups, all one sentence, as designated by the Security Council and as may be further agreed by the International Syria Support Group and endorsed by the Security Council pursuant to the statement of the support group, and to eradicate the safe haven that they have established over significant parts of Syria and Iraq. So this is all one paragraph. It's a key provision in that resolution. The main words there, the ones that we normally associate with an authorization to use force, are use all necessary measures. Okay? That's normally diplomatic code for use force. But what is intriguing about this resolution and how it departs from sort of established Security Council practice is that even though in the preamble and in one of the operative paragraphs, the Council determines that ISIS presents a threat to international peace and security, which is the determination you associate with Article 39, which is part of Chapter 7 of the Charter. The Council does not use the other magic words that it normally uses, acting under Chapter 7. It also does not, in the operative paragraph, use the words decides or demands or requests or authorizes. It uses the words calls upon, okay, which normally does not use when it authorizes uses of force. And finally, it says that states should take all necessary measures in compliance with international law, in particular with the UN Charter, which is again something it does not do when it authorizes the use of force. So I regard this paragraph as sort of art. It's like an abstract painting. You can appreciate it without necessarily understanding it. And that's the whole idea, is that it's obfuscating, right? You don't know what exactly it does. Now, the point of all this language was that each party to the conflict, each side represented the Security Council, can use this resolution as supporting what it wants. So Russia can say, validly, right, this is not an authorization to use force that goes beyond whatever legal authority pre-existed. So if the United States, UK, France strike at ISIS in Syria, and they don't have the consent of the Syrian government, the lawfulness of what they do depends on their self-defense claim. This does not add to that claim. It does not detract from it, but it does not add to it either. Similarly, Russia's rationale for using force, which is the consent of the Syrian government, is also not affected by this language, okay? Through this, everybody gets what they want without creating any legal rights and obligations. It can be deployed very, very strategically. So you will know that a while ago, David Cameron, the British Prime Minister, wanted to intervene in Syria, but Parliament wouldn't let him. So Parliament voted to approve the use of force in Iraq, but not in Syria. Now, so just last week, the UK Parliament voted to authorize the use of force in Syria. And this resolution was a major part of the parliamentary debate. So everybody used it. David Cameron used it. Jeremy Corbyn, the leader of the opposition, used it. He said the resolution is not a clear and unambiguous authorization of the use of force. But Jeremy Corbyn's shadow foreign secretary, who supports the strikes, who gave this impassioned, wonderful speech at the end of the debate, he said it is clear and unambiguous, and it does allow for the use of force. So again, you can use this precisely because it's crafted in this vague and ambiguous way to support whatever result you want to reach. So, the German Bundestag, as you know, also voted to join the international coalition. So as you can see on the example of the jus ad bellum, we are in this state of flux, in this state of indeterminacy. However, the trend, to my eyes at least, seems going clearly towards one direction, which is that the idea of collective security will mean less and less, and that the idea of individual state action on the basis of self-defense against non-state actors will gain more and more and more traction. I think that's the direction we're unmistakably heading towards, even if we're not there yet on purely formal grounds. Okay? Now, if we wanted to talk about the jus ad bellum, we could talk about many other issues. We could talk about, the irony/hypocrisy of Turkey shooting down the Russian airplane for violating their airspace for 10 seconds, and then Turkey sending a whole contingent of troops into Iraq without the consent of the Iraqi government and refusing to leave when the Iraqi government told them to. So there are many, many, many things we can talk about here, but the point I really want to carry across is how what we lawyers normally want, which is clarity in the rules, it's not necessarily the best thing for these types of issues. And how states love the fact that the indeterminacy and the ambiguity in the legal framework allows them to make all sorts of arguments while protecting their own essential interests. Let me now move to the jus in bello, the law of armed conflict. Again, after 9/11, there have been too many issues of IHL to count that have proven to be controversial. The status of so-called unlawful combatants, the rules of detention, treatment of detainees, the whole question of civilian participation in hostilities and what does it mean for somebody to be directly participating in hostilities, and so on and so on. The big question, however, to my mind, the first question, is whether the law of armed conflict applies in the first place. So are we at war, quote unquote? Are we in armed conflict? And as I said before, the position of the United States government was that, yes, the US is in a state of armed conflict with Al-Qaeda and with its associated forces, which now apparently includes ISIS, even though they hate each other's guts, right? And this armed conflict is global in scope. Originally, the theory was that this was an international armed conflict. However, not an international armed conflict that's regulated by the Geneva Conventions. This is very confusing. So the whole idea was that there were some international armed conflicts that they're not waged between states. Then came this important Hamdan case before the US Supreme Court, where the Supreme Court said an international armed conflict by definition has to take place between states. And from then onwards, the position of the Obama administration, the Bush administration and the Obama administration has been there's a global non-international armed conflict with Al-Qaeda, which sort of, I have said is an oxymoron. It's like a vegetarian alligator, right? A global non-international armed conflict. But what has happened, nonetheless, despite all this pushback, so the ICRC still says, for example, that no, we should look at each armed conflict discretely. So there's an armed conflict in Iraq, there's an armed conflict in Syria, there's an armed conflict in Yemen, but there's no global armed conflict, yes? And that would be the position of most traditional IHL scholars. Nonetheless, we are now taking for granted some positions that were avant-garde at the very best 15 years ago. So for example, most people would agree today that non-international armed conflict is not synonymous with internal armed conflict, meaning that there are some non-international armed conflicts that are cross-border or transnational in nature. So for example, when the United Kingdom bombs ISIS, a non-state armed group on the territory of Syria, say that's a cross-border non-international armed conflict, at least if you disregard the lack of Syrian consent about it, okay? Or when the UK and all the NATO countries assist the Afghan government in fighting the Taliban in Afghanistan, that's an internal armed conflict from the perspective of Afghanistan, but it's a cross-border non-international armed conflict from the perspective of all of these intervening states. So somehow, we have, over the past 15 years, accepted this position as relative orthodoxy. Yeah? I'm not saying this is a bad thing. I'm saying it's a thing. Right? It happened. And it happened because, at least because it was no longer politically possible in any conceivable way to say, this is simply not regulated by international humanitarian law. There are many, many controversial questions about this scope of applicability of IHL that remain to be decided. Just look at Syria. Just look at how complicated Syria is from a classification of armed conflict perspective. So you have ISIS fighting the Syrian regime. You have Russia striking at ISIS, but also striking at the other rebels. You have the Americans and the international coalition attacking ISIS mainly. Sometimes, however, perhaps striking the Assad regime as well. You have Turkey doing similar things. You have Turkey shooting down a Russian aircraft, etc., 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 right? So you have international armed conflicts layered upon non-international armed conflicts. It's a horrible mess. And which particular conflict you're in depends on who the actors are and how you can do the classification exercise for those particular actors. We have an enormous amount of complexity when it comes to temporal and geographic scope of armed conflicts. So for example, imagine Germany and France are at war in international armed conflict, and a German soldier meets a French soldier in Switzerland. Can they kill each other under IHL? So do they carry the international armed conflict with them? Or does the law of neutrality somehow step in and stop that? Okay? What do we do with non-international armed conflicts and their geographic scope? So are the Paris attacks in some way part of the armed conflict in Syria? That's at least a conceivable argument. The French have not, to my knowledge, resorted yet to any IHL-based rights or powers on French soil, unlike the Americans. So the United States is basing the detention of all those people in Guantanamo, right, on the idea of law of war authority. So the French are yet to do something like that. So the fact that Hollande is using this rhetoric of war doesn't necessarily mean that France has now adopted all of the positions of the US government. But that may well change, depending on how the political situation unfolds. If Geneva has terror threats, of all places, you can imagine, right, what pressure exists on governments to perhaps modify the positions they have taken so far. One big question of contemporary IHL that is currently being litigated through UK courts is whether there exists positive authority to detain in non-international armed conflicts under international humanitarian law. So this is a case called Serdar Mohammed, which has finished, went through 2 stages, through the High Court and the Court of Appeal, and is now pending before the Supreme Court, where the issue was whether the detention of an insurgent in Afghanistan for longer than 96 hours complied with the European Convention on Human Rights. And the British government's justification for that detention was essentially he was detained in the course of a non-international armed conflict, and IHL grants us a positive entitlement to detain. Both of the courts that have heard this case so far have said no, it does not. So IHL in non-international conflict is simply a body of prohibitory rules. It tells you you must not torture people, you must not kill people in these circumstances, etc. It does not, however, grant you or the non-state groups positive entitlements to do anything. But you can see what an important question that is. And as I said, it is currently being litigated before UK courts and may also end up in the European Court of Human Rights. That brings me to the last topic I will look at, which is human rights law. Specifically, human rights law in emergencies, human rights law in armed conflict. You also know that this whole question of how human rights law interacts with international humanitarian law has been something that we international lawyers have obsessed about for the past 15 years. I mean, mountains of scholarship have been written about this. But what makes this whole project tick is the fact that unlike IHL, which has very few enforcement mechanisms, human rights law has courts, treaty bodies, etc., that you can go to and have a case. So it is very appealing to prospective applicants. And that's why the European Court of Human Rights has, in recent years, heard more and more cases dealing with armed conflict situations. Currently, for example, with regard to Ukraine, there are 3 interstate cases between Russia and Ukraine pending before the European Court. And there's more than 1,000 individual cases against either or both of these states dealing with the conflict in Ukraine. So essentially, these human rights mechanisms are used to bring human rights law to these extraordinary situations. As you know, a whole host of issues is also raised with in this regard. So for example, there's this whole question of extraterritorial applicability of human rights treaties. When the UK sends a drone into Syria and kills 2 UK nationals, as happened a couple of months ago, do they have the right to life vis-a-vis the United Kingdom under the European Convention on Human Rights? That has produced a lot of contradicting jurisprudence, but the trend has been in recent years, ever since the Al-Skani case, for the European Court to take a more expansive approach to these issues. So essentially, the court has applied Article 1, the jurisdiction clause of the European Convention, more and more flexibly. Then there's this whole question of derogations. That's a mechanism, as you know, that exists in human rights treaties that allows states to get some flexibility in times of public emergency, that allows them to depart from the full extent of their obligations under the treaties. They are provisions that have been invoked fairly rarely. In sort of the terrorism context, the best examples are derogations made by the UK during the Troubles in Northern Ireland, the civil strife in Northern Ireland, where in order to intern people whom it suspected belonged to the IRA, the UK had to derogate from Article 5 of the European Convention, which prohibits preventive detention. After the Paris attacks, France has also derogated. But it has derogated in a very vague, ambiguous way. It has said, essentially, there's a public emergency in France. We have had to invoke a state of emergency, taking some extraordinary measures. Here are all the laws and decrees we have adopted on this. I mean, literally attaching this whole thing to the derogation notification and then saying some of the measures we have adopted may require a derogation to the European Convention on Human Rights, so please consider this to be a derogation. And that's exactly what they did. So France does not say we need to derogate, say, from Article 8 to the European Convention because we need to use surveillance now against our citizens or against people in France more than we used to. Right? So we have no idea what France actually purports to do through this derogation. We have no idea what the European Court will do with it, if and when a case comes before it. Ukraine has also derogated with respect to the situation in eastern Ukraine. Their derogation notification is much more elaborate. It mentions the fact of an obvious ongoing armed conflict and the fact that the Ukrainian government lost control over that part of their territory. But the Ukrainian derogation is also very interesting because it does not invoke clearly the use of law of armed conflict powers to depart from normal regimes under the ECHR. So, for example, to depart from normal rules on how when a taking of life is permitted or when a taking of liberty is permitted. So again, there we also don't know what the courts will do with that derogation. One possibility that is now becoming increasingly more important, I would say, is that of extraterritorial derogation. When the UK, for example, or the Netherlands or whoever went into Iraq and Afghanistan, they did not derogate from the European Convention. The reason why they didn't do so is because had they done so, they would have admitted that the Convention applies, which was their first line of defense. Now, however, in a series of cases, we know that the Convention does apply. So that first line of defense failed. But unfortunately, there was no derogation. Bummer, okay? But there's a question of principle, right? If the UK invades Iraq and occupies a part of Iraq, can it say there's a public emergency threatening the life of the nation? Which nation, right? In southern Iraq. So we need to resort to extraordinary measures, like, for example, internment. So they haven't done so, right? So we don't know whether, for example, it's even possible. UK courts have said in obiter dicta that this is not possible. But for my mind, at least, the more we accept that the Convention can apply extraterritorially, the less sensible it seems that states cannot derogate on the basis of in extraterritorial situations. So my feeling is that in future armed conflicts, or at least future interventions, think again France and Mali or wherever, there may be more of a temptation to derogate, or at least you have nothing to lose by doing so. Okay, we have seen also from the Strasbourg Court how in recent cases it has started to show some backbone. So it appreciates that it is operating in a climate of fear and that states are adopting increasingly aggressive policies in combating terrorism. So it has started to push back. It has started doing so, for example, in the surveillance context. Just last week, there's an important case against Russia. It has started doing that with regard to the occupation of Iraq in cases like Jaloud and Al-Skani, while giving states some room for flexibility and accepting the fact that they are in extraordinary situations. However, as you know, the European system of human rights protection is currently on the brink. It is experiencing existential threats from many different corners. For example, from the United Kingdom, where the question of UK's continued support for the court is very much open, or from Russia, where a law was recently adopted that allows Russia to essentially ignore judgments from the Strasbourg Court, et cetera, et cetera, et cetera. So the question is really, how far will the Strasbourg Court be able to effectively push back against some of these aggressive policies? So let me conclude. I hope you have seen how in all of these three areas, the past 15 years have brought many, many new different legal issues and new competing legal positions. And now the climate is such, especially after Paris, but especially in light of all the crises that Europe and the rest of the world are currently facing, that many of the positions that used to be regarded as extreme or fringe are becoming mainstream. I'm not saying this is necessarily a bad thing. You may well think that the previous fringe position should become mainstream. But this is exactly what's happening. Perhaps, you know, I think if one wants to push back against some of these extreme positions, one should be strategic about it. It seems impossible that you can push back on all fronts. Perhaps the human rights front is where states will find the most constraints on their action, especially in light of the existence of all these institutions. But then again, these institutions themselves might fail. So thank you so much. I look forward to your comments.
Thank you very much, Marco, for this presentation. There is a lot on the table, and I look forward to hearing Patrick and Antonio acting as discussants. The floor is first for Antonio.
For me? Yeah.
Okay, Antonio.
Thank you. Thank you, Marco, for your excellent presentation and for sharing it with us before you actually delivered it, because this facilitated us a little bit. Before getting to my comments, I would like to encourage all those who are standing in the back to come sit in the first 2 or 3 rows, because there are a number of free seats.
Only 2?
And
more.
yeah.
Yes,
So-
there are more. Yeah, I didn't see them.
Yeah, in the second
Yes.
row especially, there are
Yeah, please
quite a
come
few
and
seats.
Take your seat.
And you know, I'm quite anxious as a person, and if I see people standing, that's even worse. So please help me. Yeah. So I just have a few remarks, mostly because for the greatest part, if not in the totality of what Marco said, I agree. I would just like to maybe ask you for your opinion on certain things that you didn't delve into, or to add a few things concerning the resolution 2249 that was recently adopted. You talked about a shift in the way we conceive collective security, and probably you were quite diplomatic. I think what we witnessed with this resolution was a failure of the UN collective security system. If the main mission of the United Nations was to ensure that force was used by a supranational entity, I think we have failed. And probably it's still better than the pre-United Nations world, but it's certainly not what the drafters of the Charter had in mind. And I have to say, I have no idea of how to reverse the trend that you highlighted. I don't know. The only way that I see would be a reform of the Security Council, but that's kind of impossible. So probably, yeah, that's a failure. And maybe after the League of Nations, the United Nations, maybe we'll need some other big catastrophe that pushes us to do something more. I don't know whether that will come.
Thanks for inviting World War III.
Yeah. Specifically about Resolution 2249, you mentioned the fact that it doesn't mention Chapter 7. I think you agree with me this is not conclusive. I mean, the fact that it doesn't mention it, it doesn't mean that it doesn't apply it. It doesn't have to say it explicitly. Of course, it doesn't decide anything, so it's kind of moot to discuss whether it is adopted under Chapter 7 or not, even though it has its relevance. One thing that I want to ask you is whether the fact that it calls upon to adopt all necessary measures includes an encouragement for Syria to give its express consent to the airstrikes by states who haven't been officially invited. And in this respect, if you have a position concerning the issue of military intervention by invitation during civil wars, whether you can explain to me what the position is, just for the public. There is a minority opinion, I would say, that it's who are quite supported in the doctrine that says that military interventions by invitation are not allowed during civil wars or internal armed conflicts. And when we take into account the fact that Russia, invited by the Syrian regime, is not only targeting Islamic State, but it's also targeting the rebels, that's something that we should clarify. The third thing that I want to ask you is whether this resolution, talking about a global and continued threat to international peace and security, establishes, in fact, that Islamic State and associated forces pose a permanent threat which satisfies the imminence requirement for, let's call it, self-defense from imminent attacks, whether basically it's a permanent threat, we can do whatever in self-defense without the need to justify each and every time that there was an imminent threat of an armed attack against the state. And well, I think I've said enough. Just one last thing. You mentioned the mess in classification that we have in Syria and Iraq, and I agree. I believe it was 1 year ago when we had a similar event to this one. Jean-Baptiste Maillard and I were presenting on the conflicts in Iraq and Syria, and we started classifying all the conflicts, and it was like 10 minutes just listing all the existing conflicts a year ago, imagine now. But I wonder whether the classification exercise sometimes it's a little overestimated. Because, frankly speaking, most rules, especially those on conduct of hostilities, they are pretty much the same in international and non-international conflicts. Where I see the difference is, of course, with regard to detention, but so far that hasn't arisen very often that I know about. Yeah, I would say that that's all. Just one last remark. Again, on Resolution 2249, I think it kind of implies, you say it in one of the things that you have written, kind of implies that human rights law is applicable extraterritorially, right? Because it says the states must take all necessary measures in compliance with international human rights law. But they are taking these measures mostly outside of their own territory. So this wording kind of implies that human rights law are applicable extraterritorially. Arguably, I think we have a good case. Bottom line, I think that we are in a state where states can do pretty much whatever they like, as long as they justify it relatively well. I'm a little disappointed that France didn't explain better the derogation, because it's probably because they want to save money on their legal advisors, you know?
No. No. They have good legal advisors working for the foreign ministry. So they don't want to explain because vagueness is a tool.
Yeah.
Vagueness is a weapon. So it's like when, for example, they sent a letter to the Security Council. It says, France is now exercising its right to self-defense. Full stop. Self-defense with regard to what armed attack? With regard to, is it collective self-defense of Iraq? Is it individual self-defense of France? Self-defense, full stop. But that's how they think. It's clever, you know? It's very clever, that. Sorry.
No?
Yeah. But it's not lack of lawyers.
So they were not on vacation, in your opinion, no?
Certainly the people who drafted this are artists.
Okay.
Yeah.
Well, as you say, it's intentional ambiguity. Well, thank you. Well, we'll reply later. Let's listen.
Thank you. I give the floor also to Patrick, although I have some
you jump into it.
I need to jump on some issues. But I will do it later. So Patrick, is up to you.
Okay. Well, thank you very much. So I mean, these issues are incredibly complex, and as I was preparing for this.
Patrick, speak in the microphone.
Oh yeah, can you hear me?
Marko. Okay, Marko.
So it was already extremely complex for me. It's even more complex now in a way, and it's hard to make sense of all this. But I mean, one thing that really struck me, and I do want to highlight this. I'm a little bit surprised that Marko was saying that basically Europe has already conceded the American position. So basically that it is in the process of acknowledging that some of the extreme positions put forward by the United States are being endorsed, so that Europe might be going in that direction. I didn't think that that's the case. I didn't think that was necessarily happening. I think it is happening to some extent. But I think it's really interesting to think about this because obviously it is a complex issue, a complex set of issues, so human rights, humanitarian law, and the use ad bellum. But I get the feeling that maybe what's happening is that we don't have consensus within Europe. We can also look at this depending on the state. So we can try and make distinctions between states within Europe. So there might be a fragmentation of the scene. And I'm interpreting this slightly differently because, for example, I completely agree that France, when they sent that letter to the UN Security Council, they did that on purpose. They're keeping it vague on purpose. I don't think it's because they don't have good lawyers or they were on vacation. And the same for the derogation clause. And my interpretation of that would be that France feels intense discomfort with these positions that it is embracing right now. And in a way, it's trying to have its cake and eat it. It doesn't want to acknowledge that what they've been arguing against for so long is now becoming the mainstream position. Maybe they're holding out and just waiting for things to change. It might be a naive belief, I don't know. But if you contrast the French position with the British position, I think it's very clear that there is something going on here because the British are a lot closer to the U.S., and they have been for a long time. Of course, they invaded Iraq with the U.S. France did not. And the British, it almost seems like, are very willing to jump on the bandwagon, to join the U.S., unwilling and unable, all these theories that have been definitely not mainstream for a long time. It seems like the UK is more willing to embrace them. So I'm just saying this because I think it's interesting to think about the European position. We are here in Europe, and of course the Graduate Institute being a place where international law is very important. And I think it's also incumbent upon us as international lawyers to think about these things very critically and to try and push back against these positions. I mean, again, I don't know what the answer is. This is extremely complicated stuff. But I do hope that there is discomfort within Europe with some of these extreme positions, which are, I agree, becoming increasingly mainstream. And I don't know what we can do about it, but I do think it's interesting to see that, for example, there's a distinction to be made between, say, France, the UK, and of course in Germany something completely different is happening right now. The Germans are also discussing these issues, sending troops to Syria, but not for combat purposes. So I just wanted to put that out there. There's another thing, so a completely separate issue in a way, the use ad bellum specifically. So I'm wondering about this because Marko mentioned that what the resolution does, 2249, is that it expands the scope of self-defense. So the Article 51 self-defense justification, or whatever you want to call it. And you said something that I found very interesting, because you said that we're going from self-defense to unilateral use of force. Or from collective measures to unilateral measures. And I think that's true. It's exactly what Antonio said a moment ago, that it is a failure. 2249 is a failure of the collective security system. And basically what it's doing is it's endorsing or legitimizing this idea of unilateral force. And I mean, for me, though, I wonder about this sometimes, because I wonder if we're talking about the same thing. For me, self-defense is a provisional measure. It is supposed to be, at least in theory, a temporary measure. So you exercise self-defense under the use ad bellum. I'm not talking about self-defense, of course, in national law, but under the use ad bellum, you have to satisfy the proportionality and the necessity requirements. And by its very nature, self-defense is limited in scope. Self-defense is not an authorization to wage war. At least that's how I understand it. And what's interesting to me is that increasingly self-defense is being put forward as sort of a legitimation of war. You can go to war because you are acting in self-defense. But I think those things, if you look at Article 51 allows self-defense, but then you have to involve the Security Council. So it's not that you can invoke self-defense and then you're allowed to wage war. And so, again, this is very problematic because we're extending the scope of self-defense, but in a way, it defeats the purpose of self-defense in the UN Charter, because the UN Charter is supposed to be a limitation on the right to wage war. And self-defense, the way it's being deployed by states now, and also in 2249, it's basically a license to wage war, the way I see it. And I don't know, again, that's how I view things, but again, I think these things are very unclear at this point. What I would say also with respect to self-defense is, Marko touched upon this briefly. There's the issue of non-state actors, and one of the things that's interesting when we talk about non-state actors is that the assumption here seems to be that when we talk about non-state actors, we're talking about armed groups, but individuals are also non-state actors. And I mean, the way the UK, and the UK did this, but before them we had the US, which killed al-Awlaki in Yemen. But the way the UK deployed the self-defense argument to take out 2 British nationals in Syria in August, to me is deeply, deeply disconcerting, because self-defense here, Article 51, the jus ad bellum, is deployed in a way where it provides cover to kill people. And of course, I know that you've written extensively on this, the issue that the jus ad bellum doesn't mean that you don't perform an international human rights law analysis. You still have to justify a killing under international human rights law. But the way it's being deployed, the jus ad bellum argument, the self-defense argument, it seems like states are now content with invoking Article 51 to kill people. And I don't think that's enough. I think we have to go a bit further, and we have to really question states about what they're doing, because that's not the purpose of self-defense. The way I see it, self-defense under the UN Charter, Article 51, is not a means to assassinate people. So I think that's extremely problematic. I think maybe I'll just say one more thing about this whole situation, and specifically the Resolution 2249. I think there's discomfort with what's going on, obviously, and I'm quite pessimistic about this, but the reason I'm pessimistic is because the language that the resolution uses, declaring that ISIS is an enemy of mankind, basically. To me, what we're doing potentially here is we are removing them from the protection of the law. So we are basically creating a category of individuals that is beyond the law. And I'm not sure that this is the way forward. The way the resolution talks about ISIS, it seems that we can invoke the jus ad bellum to attack them almost anywhere. It talks about Syria and Iraq, but some of the language is extremely broad. Mark Weller has written about this, that one could interpret the resolution as an authorization to deploy force against ISIL anywhere in the world. And this brings us to the whole global battlefield discussion about the global battlefield. And in a way, I mean, my concern with 2249 specifically is that it's taking us back to, the pre-UN Charter days. It almost seems like we've created a group that doesn't deserve our protection. These aren't human beings, and we can deploy force without any legal constraints, and I think that that's potentially a serious problem.
Excellent. Thank you very much, Patrick, for your comments.
One last thing, 30 seconds.
30 seconds, yes,
Yes.
but only 30.
No. Just talking about the political climate where we would kind of buy whatever explanation is put forward, or at least large parts of the public opinion would. I'm kind of surprised, that I don't know what you think about, by the fact that the justification of humanitarian intervention is not being put forward so much. Actually, if there was a political time when to establish state practice for this, I think it's this one. But they are not doing it. Why aren't they, in your opinion? And yeah, exactly, your thoughts about it.
Okay, we have a lot of issues on the table. I want to give the floor, of course, to the audience. I think, however, the comments by Patrick are very important comments, because rather than self-defense, we are going back to self-preservation in this pre-charter era, where states were authorized to use force to self-preserve themselves, because, of course, we are very clear that regardless of the attribution test under Article 51, the problem are the other requirements required by customary international law to apply self-defense, which is to repeal an armed attack, and if the terrorist attack is over, what kind of attack are you repealing, what is the purpose, the proportionality, and all these matters, of course, are important, and therefore I think we are more on self-preservation than the self-defense. But leaving this aside, I would like to reread with you the paragraph that you mentioned, because it's true that it's not, that you read out, because it's true that it's not deciding, but this is not irrelevant, the fact that the Security Council recommends measures in conformity with the Charter, because it can be also non-forcible measures necessarily. And there is an Italian, very well-known international lawyer, whose name is Benedetto Conforti, who also claimed that the recommendation by the Security Council and any UN organ, they produce a so-called legality effect. So though you are not obliged to follow a measure which is recommended, the fact of acting on compliance with the recommendation will remove the illegality of any kind of other activity that you do to follow the resolution. And since this is a very broad recommendation, in principle, you might justify a lot of measures irrespective of the use of force, but this is something that it is too technical, and I will leave it. So the public is there. The floor is yours.
Thank you very much. I'm Steve Baila from the Global Studies Institute across the way here at the University of Geneva. I want to thank you very much for the presentation. It was very good as clarification of ambiguity. I think Duke Ellington might call it harmonious dissonance. It was very nice. Very nice. Thank you. My question, I want to push you into a little bit of a different territory than you spoke about. You talked about. Thank you very much. You talked about how the law has been distorted and moving over the last 15 years, if you will. And one of the questions I wanted to ask you about was about where you would classify the question of the prohibition of torture today, particularly in the light of last year's Senate Select Committee's report out of the United States, and then in particular dealing with the new National Defense Authorization Act that was signed by President Obama over Thanksgiving weekend. That should be codifying what he put into effect in an executive order on the second day of his presidency, that all agencies of the United States are bound by the U.S. military manual. And so what I'm wondering about is how you might classify where torture stands today. We had a lot of fears and worries about what happened with the question of torture after September 11th. And there seems to be a bit of a pushback in that particular area.
Thank you. I guess that perhaps we can take a few questions and then we can... Better that we take the micro. Thank you.
Thank you very much. Yes, thank you very much for the presentation, and thank you for being here with us tonight. My question is on...
Your name first, please.
My name is Michael Riepe, and I'm actually a former student of yours.
I know, but it's not for me.
No, also of Mr. Milanović.
Marko, yes.
No, so anyway, my question was on an issue that you have brought up, which is the participation of Germany now in the conflict. And I was wondering how you see the role of countries who claim to do only support and logistic and reconnaissance. Would you consider them as a party to the conflict or not? I mean, just to summarize, Germany is claiming that, well, what they're doing is they're providing reconnaissance planes, satellite pictures, they're protecting a French aircraft carrier, and they're providing air refueling means. So would you consider that as participation to the conflict?
And we take a third question, the gentleman over there. Yeah. Me. You seem to be one.
Maybe my name is Boris Engelson. I am a city journalist. Maybe my question goes beyond the scope of your expertise. What is the likelihood, in your view, of the United Nations collapsing in the 10 coming years, and Geneva Academy sending its commentaries from a concentration camp?
Okay, I guess that perhaps we can take a 3 by 3 if you are quick in answering those questions, although they are very difficult ones.
Sure. And I have Antonio's and Patrick's.
Perhaps we can have other 3 questions.
So can I actually start with the questions from the audience, and then I'll come back to you guys. Oh yes, sorry, I will. So first, regarding the question on torture. So I think this is one example where the pushback by various actors outside the United States, but also various actors within the United States, actually worked. So today, if you see, enhanced interrogation, or however you call it, is no longer on the table, at least if you talk to rational people. So, now when you have, I don't know, the Republican primaries and Donald Trump stands, I'm going to torture everybody, I mean, it works in that setting. But any kind of rational policy person, whatever, right-wing, left-wing in the United States at least, thinks that enhanced interrogation brought more harm than good. So even if you look at it in purely utilitarian terms, was it good for the United States that they did it? Other than Dick Cheney, everybody agrees it was bad. And so the pushback actually bore fruit. And it's remarkable now the European Court of Human Rights will actually reopen the Ireland versus the UK's case. Remember that case where they said the 5 techniques that were used by the British in Northern Ireland that were not torture but just cruel and inhuman treatment that the Americans actually used in the interrogation in the interrogation program. Now the case is being reopened because of the evidence that the UK misled the court. So I think this is one area where the pushback worked. But that was my point. I think if you want to push back, where will the pushback strategically work best? Is I think the big question. And frankly, I don't think jus ad bellum is really it. We had, and I'm now answering many questions at once. We had there was an ESOL conference in Oslo in September. And it was a very nice panel on ISIS. And most of the people in the panel were European jus ad bellum scholars. So for example, there was Olivier Courtin, there was Theodore Christakis, whatever. And they were, crystal clear that for them the law was, as it was stated in the Nicaragua case, that the whole unwilling, unable thing is just nonsense. That what all these intervening states should do is get consent from Assad, and that's it. Yeah. So, but for half the world, that is not a conversation that makes sense anymore. So, I don't think pushback will work there necessarily. That brings me, Michal, to your question on Germany. I have a very nice quote from the German foreign minister, which actually illustrates well how this mainstreaming of extreme position happens. So when he was asked about Article 51, does that require attribution, in the Bundestag during the debate, he said, and I quote, very clearly, and it's not clear, to the question of Article 51 self-defense, I reply, we are here not in a seminar. After in total 8 attacks that happened in France, this is not the hour to explain to the French that they need not feel attacked. That they were not attacked. Understand? It's over, right? To an extent, that debate. So if in the German Bundestag, the German foreign minister said, forget this nonsense, this academic stuff, the pushback is not going to happen, okay? So are they participants in the conflict? I would say so long as they're supporting combat missions of other states, yes, they are participants in the conflict. If I am sending a bomber and you're refueling my bomber, the fact that you yourself are not dropping bombs does not mean you're not participating in the conflict. You're directly supporting my combat mission, so you're involved in the conflict, however that conflict is classified. So the reason why the Germans are doing that is the whole politics of pacifism and the legacy of World War II, but it doesn't mean they're not actually fighting. They're fighting without fighting. The question of the collapse of the UN, sure, you know, that might collapse. The European Union, as is more likely, might collapse. I mean, who can tell the future? But I doubt, at least so far, what we do has some use to it. Because if you look at the whole enterprise of international lawyering, these debates are still had in this language, in the language of international law. And the language of international law is applied to all sorts of contemporary issues of international relations, like, for example, the climate change thing in Paris just a few days ago, where the big thing was whether a should be a shall, or vice versa, because if it is, you know, it's a treaty. You know, I wouldn't be so horribly pessimistic about it. Can I not answer your questions because I've talked too long? And I'll cover them as and when the questions from the audience sort of arise.
The one by Patrick or the one by Antonio?
Both of you. I have a whole list, right?
Okay, although they were more comments,
and
then we can continue with their questions at dinner in any case.
Yeah.
So let's take more questions from the floor. We have Tom Gall. I'm surprised that Professor Clapham does not say anything.
Why are you putting him on the spot like that?
Yes, because he's there, the first one on the first row, therefore I notice him. Then we have a gentleman over there, and Tom.
Yeah, sure. I'll make it quick. Hi, Tom Gall from the Geneva Academy. Thanks, Professor Milanović, for being here, and thanks to my colleague Patrick and Antonio, and you, Professor Gaeta, as well, for this extremely interesting panel. Two and a half quick questions. The first one is, you mentioned that we are at the point of agreeing that there is a difference between an internal and a transnational, non-international armed conflict. As a person who kind of like the issue of classification, I'm trying to understand to what end, what law would apply to this transnational, and what or how would it differ in your classification from an internal classic non-international armed conflict. And regarding to 2249, I might be in a minority. I don't like this resolution. I don't like it for many reasons, but I'm not sure it's a total failure. I think on the other hand, on the one, it's kind of a backwind to Assad regime, not only mentioning ISIS, but also other rebel groups operating in Syria that are not at all connected to ISIS, such as Jabhat al-Nusrat and others. And to me, that's the mere question, is whether this resolution is actually about Daesh or about any non-state armed group operating in the territory of Syria. Thanks.
And the half?
That's the half.
This was the half.
No failure.
Here we have a gentleman over there. Yes, thank you. So there is another one about the one leaving us now.
Thank you. Peter Splinter. I'm with Amnesty International. Thank you. That was a very interesting expose. If we're concerned about how to avoid the extreme becoming the mainstream, or concerned about the current trend, I wonder if there aren't two elements to it. And one, which has been addressed this evening, is how do we use the law to hold the line or push back? But isn't there another element that perhaps is much more political than legal, but it's just this whole acceptance of the war of terror, this endless war, this war without any objective end to it, that's reflected in comments like or passages like the one Antonio highlighted, perpetual imminent threat. And shouldn't some of our thinking be going to challenging this concept of a perpetual, that's not there, endless isn't there, but war on terror?
Thank you. I guess that we can take a third one. Jérôme, you must say something on the classification of conflict. No. Okay, so, no, there is another one, sorry. Thank you.
Willy Koch from the University of Geneva. I have just a very short question on your own opinion, whether 2249 is actually contributing to peace and security, and whether this isn't whether the United Nations Security Council didn't not do what it should do, and if it's too broad, contributing less to peace and security than it actually should, if you understand what I mean.
Yeah.
Okay, excellent. Thank you. So, Marko.
So, you know, two questions on 2249. I don't think it was a failure, and in that sense, it perhaps you could say it did contribute to peace and security in somehow. So, yes, this is not the traditional collective security approach as envisaged by the intentions of the drafters of the Charter. But that horse has been dead for 50 years, right? So, in that sense, we can't get there. Right? There's no way to be in the world that the drafters of the Charter intended. Remember, the drafters of the Charter intended the United Nations to command enforcement action, not the United Nations to authorize individual states to do it. So the whole Security Council authorization thing is a post-Charter construct that we have created, right? Out of the whole, there should be UN General commanding the invasion of Iraq thing, which never was on the cards, okay? So in that sense, the fact that it brings all these political players together is a good thing. I think it is a good thing, genuinely, for Russia and France and China and the United States and Germany and whoever to sit together and say, we're going to do something. However, whether it will in fact contribute to peace is an empirical question that is contingent on developments we know nothing about. So what concerns me most is the fact if you look at the Syria conflict, there's simply no strategy. So forget the law aspect of it. There's no end game. How exactly do you plan to win? Nobody has that. The only way, right, if you ask a general how would you win, is to send 300,000, 400,000 troops there. Nobody's going to do that. So all of these European Western states are now saying, well, we should have Arab states contribute troops for a land mission. Right. Right. Saudi Arabia is, running, to assemble its army. No. I mean, so that's what concerns me. So in that sense, what this could also achieve is simply further loss of life. But on the other hand, the ambiguity allowed these actors to come together politically, and I don't think that's a bad thing compared to the alternative. That is better than for them to fight each other. Coming back to your question about the cross-border NIAC thing, the law that would be applied would be the law of non-international conflict. If you ask me, there are only two classifications, which is international armed conflict, non-international armed conflict, or no armed conflict. So it's either one of these two or nothing. So I don't mean to say that we have a special kind of armed conflict with special rules. I am saying, however, that the orthodox thinking used to be that there is internal armed conflict and international, and that's it. And Lindsay Moore's book is called The Law of Internal Armed Conflict. But now we know that there are many non-international armed conflicts that are not simply internal. They can spill over, they can have foreign interveners, whatever, and we will cover this under the umbrella concept of NIAC. And finally, on your comment about the endless war point, I agree, that's the big thing. So that's how we as lawyers have pushed back against this idea of never-ending global amorphous conflict with all these organizations that, like Al-Qaeda, that are not really organized armed groups in the traditional sense. But as you said quite correctly, I think where this needs to be fought is politically, in public debate, with politicians, with people on the streets, not as lawyers. So our role is, well, we have our only very limited role to play there. But if the public buys into the endless war premise, we lose. There's no way we can overcome that.
If I may add one thing about the...
No, I would like first to see if there is any other question from the public, because then we conclude and we do a tour from the table, okay? There are two gentlemen there, because we have other 10 minutes.
Yes, about the terms, take all necessary measures. Does it imply automatically shelling, bombings, and add more violence? Has it not possible to have more dialogue and take non-violent measures? Is it also possible to think that?
Thank you. Yeah, the gentleman there.
just a naive question. You didn't mention anything about the fact that the perpetrators of the attacks in France were French nationals.
Yes, it's an internal.
Does it change something in terms of attacking another state, etc.?
Yeah.
What are your views on that? Thank you.
Yeah, so we go back to the self-defense issue. So there. So I suggest that if there is no other question, we take this last two, and then we do a last two.
Cool. So I agree completely with your point that I agree completely with your point that the now I'm going to start singing, that the all necessary measures thing does not need to be interpreted as force, but that is the code. Either all necessary measures or an all necessary means that generally is considered to include force. So the reason why it doesn't include force here is A, because there's a lack of any real decision on the part of the Council, and because there are all of these other words, like in compliance with the Charter, that render that formula nugatory, essentially. But I agree, you know, there are many things people can and should do other than simply bomb others. Your point about citizenship is, I think, very, very important. I think you'll recall, for example, that the United Kingdom was the only state to derogate after the 9/11 attacks from the European Convention. And it did so it could preventively detain people. But the only people whom it detained were foreigners. And then UK courts and the European Court of Human Rights said, no, this derogation is invalid because it is discriminatory. Your own people can pose a security threat to you just like foreigners can. As was shown by the London tube bombings a couple of years later, right? Which was also done generally by British people. I don't think, however, that citizenship matters for these questions of IHL jus ad bellum. If the question is allegiance, really, are these people working for an organized armed group, regardless of what their citizenship is? So there are probably now 100 different nationalities working for ISIS. I don't think the law, at least these laws that we talked about, have to, you know, in order to apply, that we need to know the citizenship of each and every one.
Thank you very much, Marco. I guess that now we can have a last, perhaps a few minutes for both Patrick and Antonio, if you might have comments to make.
Just one little thing.
Also, please use the micro, yes.
Yeah. So, no, just one little thing. I was not happy with the wording of Resolution 2249, but there are some good things, I believe. There are two things that I want to mention. First of all, that we are still trying to use a legal language somehow, and these, in itself, it's not so bad, because it means that we haven't given away with the whole idea that there is a law regulating the behavior of states. So at least still the same fact that they are looking for some sort of legal umbrella, it's in itself a value. The second thing that I want to say, it's a response to Patrick's comment about Islamic State being cast outside the law and being, this evil body that basically we can do everything we want against. I think still the language of the resolution preserves the application of international law to Islamic State members. It says all necessary measures in compliance with the UN Charter, international law, international humanitarian law, international human rights law, which means these bodies of law still apply to those people. And so at least on the surface and on the paper, they are still subjects to this law, subjects of rights, not only duties, of course. So I think it's not so bad, even though it could have been better.
Thank you. Marco, just last few words to conclude?
I just don't think we need to be too dramatic about it. So, you know, it's the experience of international law that it always goes through one existential crisis to another, right? I mean, that's, Paula, I'm just loving this. You go, girl, you hold that mic. And I'm gonna sing my song. So the point I'm making is, let's not be too pessimistic. We've been in worse places before. The danger always is, will fear of terrorism on the streets of Paris, Geneva, Belgrade, London, wherever, right? will it overwhelm everything else to such an extent that we undergo some fundamental transformations we cannot reverse later? So some transformations in the international legal order we have went through, that doesn't necessarily mean they're bad. Doesn't necessarily mean they're bad. But we need to be wary. Okay? And so part, as you said, of us as the functions that we serve as international lawyers in this community is to, have some measure of restraint. So let's hope we manage to do that.
Yes, and with these words, we would like to thank you and to thank Patrick and Antonio for convening this meeting, and thank you very much to all of you for coming.
Thank you.